Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in this video session I'm going to focus on people who are shielding because of COVID-19. Now, this is a new classification that's come about because of the pandemic. There's no specific legal status, if you like. The law plays catch-up a lot of the time. Language that's used now in England is clinically extremely vulnerable. If we think back to the beginning of the pandemic, back in March, we had advice that certain people over the age of 70 with underlying health conditions or were pregnant were particularly vulnerable. And then health authorities wrote to people advising them that they should shield. Initially, when that happened, of course, there was no furlough scheme and statutory sick pay didn't cover those people. That was rectified on the 16th of April. So if somebody hasn't been able to be furloughed for some reason, then SSP has been covering them. On the 22nd of June, it was announced that in England this was going to be paused from the 1st of August, with Wales following suit from the 16th of August. Interesting that the word paused is used, because that very much suggests that the goalposts could move again and shielding could be reinstated at some point in time. So it's worth remembering that. And that change in August means, of course, that statutory sick pay now falls away for protecting people who are shielding. In terms of the guidance, employers are still very much guided to allow working from home as the default position for individuals who are advised to shield. And just because the pausing has happened doesn't mean that those people should automatically be brought back into the workplace. But where you cannot offer working from home, then you're advised to transition those people back to work safely. So what does that look like? Employers have got to do risk assessments for COVID anyway. If you've got more than 50 people, you should be publishing that risk assessment. But your risk assessment will need to have its own line or entry for this particular group of people. You might even need to break down that group into the people that you've got within that group and address specifically measures that you can take to look after them. Now, that might be creating small bubbles within the workplace and restricting who has access to that person, the number of people that they're going to come into touch with. It may be looking at alternative roles that can be done on a temporary basis. That might mean taking somebody away from being customer facing to doing something perhaps more behind the scenes. The risk, of course, is that if we get that wrong, if the employee themselves doesn't feel that sufficient measures have been taken, we could find ourselves into Section 44, Section 100 of the Employment Rights Act territory. And I've made other videos and done blogs about that if you want to have a look about more in that area. But essentially that's where employees saying, I don't believe I'm safe in the workplace. I don't think my employer's done enough to protect me. And I've suffered a detriment because of it. The detriment could be forcing them to return to work, or it could be a dismissal situation where they've resigned as a result, no longer having trust and confidence, if you like, in the way in which you're dealing with things. Just touching on furlough for a second, there is, I think, a bit of a risk area around those people who've been shielding, where at the beginning, when furlough didn't exist, we might have forced those people to be off sick or on unpaid leave or something. If they've been forced onto SSP or forced onto nil pay, when furlough then became available, if we didn't then furlough those people, they may well have claims around the differential in pay that they will have suffered. Obviously, if people are already furloughed, the furlough scheme is currently, I'm doing this on the 13th of August, currently still in place, so those people arguably should stay on furlough for the duration of the furlough scheme. And indeed, if they were furloughed for 3 weeks before the 30th of June, they can be re-furloughed if necessary. There is a lobby currently from some of the charities representing people with particular medical conditions, so Diabetes UK is an example, Trade Unions Congress, other bodies very much lobbying to try and continue the furlough scheme for people who are in that particularly vulnerable group. Particular risk areas for employers are going to be around the disability legislation, the Equality Act. A lot of people who are shielding because of underlying medical conditions will qualify as disabled just because of the way their condition affects them on a daily basis. But potentially, I think the pool of people who are disabled may get wider as a result of COVID. People whose condition perhaps wouldn't have qualified as a disability before, now as a result of the risks that COVID presents, might tip them into that definition of substantial effect on your normal day-to-day activities, where the advice to them is more restrictive and they can't go out and about and do things that they would have done previously. So watch out for that one. Obviously, disability triggers reasonable adjustments duties. The requirement for somebody to return to work could be a provision, criterion or practice that somebody then complains has put them at a disadvantage compared to other workers who aren't as vulnerable, and the employer would then potentially have to objectively justify that. And the way I look at objective justification is, unless you've looked at reasonable adjustments and can show a tribunal that you've tried pretty much everything else before you've done something, then you could get into difficulty around that. One of the other concerns I have is around selection for furlough or redundancy potentially at the end of the furlough scheme. If somebody is being selected because of their status as somebody who's shielding, then potentially you've got breach of trust and confidence type claims lurking there. But also Section 15 of the Equality Act enables somebody to say, the reason why I've been selected, behind this is my disability. And again, the employer has to have objectively justified what they're doing. And quite often, if you haven't made reasonable adjustments first, you're going to struggle to commit to tribunal on the justification side of things. So reasonable adjustments could be working from home, and that might mean doing things a little bit differently in terms of the job and making adjustments to the job to enable it to be done in that way. It might be the bubbles that I talked about before, or looking at the alternative roles. Case law on reasonable adjustments is fairly clear that if something may have a measure of success, then it should be being pursued. So COVID's complicated, isn't it, in terms of the advice and the medical knowledge and the things that are helpful, if you like, in preventing somebody from becoming unwell with it. It may be small things that all amount to a bigger picture. So you would be expected to be exploring all of those things. Another issue, of course, is people who live with people who are shielded. So not shielding themselves, they're not going to qualify for SSP. We still got that lurking risk of those Section 44 or Section 100 of the Employment Rights Act claims, where somebody's got a belief that, you know, them travelling to work on public transport, for example, might be putting them at danger, that's then going to endanger somebody that they live with. And what we have to be careful of here is the concept of associative discrimination. If the person that they live with would qualify as disabled under the Equality Act, there is a concept of associative discrimination that protects direct discrimination. So if somebody says the reason why I've been selected for redundancy, or the reason why I've been refused to be furloughed, for example, is connected with my status as somebody who wants to be shielding somebody at home, then somebody could get a claim off the ground, perhaps on those basis. So lots of issues going on. I think employers are going to have to get advice on individual cases before they make big decisions. If you've got any questions, please email me, adenton@refreshinglawltd.co.uk. Thank you very much.